All right, thank you, Eric, and welcome everybody. I think I just saw that the recording got turned on. So I am Mike Engleson. I'm the Executive Director of Wisconsin Lakes. We're the statewide nonprofit organization of lake associations, lake districts, and individual lake stakeholders. And really happy to be bringing you this series of webinars along with Eric and Extension Lakes and the whole Lakes and Rivers Partnership. But especially this topic today on liability and insurance, because I know it's something that we get questions about all of the time, both at Extension Lakes and Wisconsin Lakes, from organizations, both districts and lake associations, and we'll be sort of covering issues related to both. In a lot of instances, there's a lot of overlap, even if the statutes or the laws might come from a different place, the actual results are the same. So just quickly to go over what we're going to be talking about today. So first, we'll start with just liability in general, and we'll be joined by Jessica Harrison from Schultz Nonprofit Law in Madison. I'll introduce her in just a second. And then after she's done, Nathan, and I forgot to ask you, Nathan, how exactly to pronounce your last name. So if I butchered this, I apologize. Pazuski, did I get that right?
It's Pazeski, close enough.
Oh, all right. Nathan is from the Horton Group, who is an insurer that often deals with municipal clients, but also we have an umbrella policy for directors and officers insurance through them for lake associations who are current members of Wisconsin Lakes. And so he'll get into some issues about directors and officers insurance versus general liability and municipal insurance for lake districts as well, I'm sure. And then we'll have plenty of time because mostly we want to have this be an open discussion, because we don't know all of the questions that you have regarding these topics, and there's always lots of good ones. So let me flip over here to Jessica's presentation. All right, and really happy to introduce Jessica. So we've done work with Schultz Nonprofit Law. Melissa Schultz, who founded the institution, has presented at the Lakes Convention in the past on similar issues. Jessica, and we've done work with both Melissa and Jessica. Schultz Nonprofit Law has been really helpful through the pandemic with providing information to nonprofit organizations about the different loan opportunities and grant opportunities to help with funding. And Jessica also happens to be a much more accomplished member of the Wisconsin Law School class of 2000 compared to me. But we were classmates. So I'm happy to welcome Jessica Harrison. Go ahead, Jessica.
Hello there. Hi, everybody. I'm not sure that introduction was warranted, Mike. I'm not sure what your evidence is for our relative law school finishings, but anyway.
Mostly mine, but.
Great. Yeah, so my name is Jessica Harrison, and as Mike said, I work with Schultz Nonprofit Law and with Melissa, and had the chance to do that for about 10 years now. So it's really great, and I'm really happy to be able to present to you all. We really focus on nonprofit organizations, and it's really great to be able to help you all do good. So I want to thank you all for doing what you're doing to protect our lakes and waters. Is so important. That's what makes one thing that makes our state so great. So thank you for your work. And also, I'd say it's pretty great to have this many people appear to hear about liability and insurance and things like that are not really maybe it's very important to talk about them, but it's great that you all are here to hear right now to hear how to minimize your risk and do what you can to keep your organization in the best footing possible. So go ahead, Mike. Thank you. Next slide. So what I'd like to do is, I'm not going to read through all of this, and I assume you'll have access to these slides later. So what I wanted to do, though, is start out and just give you a little background on the benefits of being a nonprofit organization, and particularly a non-stock corporation, is that there's some pretty clear guidelines on what kind of, as a director, what kind of activity is pretty safe. It's pretty well spelled out about if you're a director on the board of a non-stock corporation, that could be a C3 or a C4. If you're organized as a non-stock corporation, that would be under Chapter 181 of the Wisconsin statutes. And under the statutes, there's some really clear guidelines on, as a director, what you can do to color within the lines to make sure that you're performing your duties. And if you do those things, then liability against you personally is very, very limited, which is great because most directors on nonprofit boards are not being paid. So knowing that you are protected from liability is really important as a reassurance. So let's move on to the next slide, please. So what I'll be focusing on is specifically for, again, non-stock corporations where the statutory protections are laid out really clearly. And the basic idea is if you are a director on a nonprofit board, if you are doing your own duty, then you have really, really pretty great protection from personal liability. So your first question may be, what are those duties? And it's really pretty straightforward and really, I think, very intuitive that basically, if you're a director and you are showing up to meetings, you're reading the minutes, you're paying attention, you're doing your best job of acting on behalf of the organization, and you're following all the compliance guidelines, then you're in good hands. You're in good shape as far as personal liability. So let's go on and quickly go through these three different duties so you have an idea of what where those bounds are. So go ahead. Duty of care, the first one, okay? So basically the duty of care really just means you're exercising due diligence and you are being reasonable and acting in the organization's best interest. The shorthand version of the duty of care is don't sleep. Really it means what would a reasonable person do if they were a director and they were presented with these particular decisions? Would they exercise the same kind of care generally? So it's a pretty broad, a lot of things can be reasonable. So it doesn't mean there's one specific decision that a board member must make. And if you don't, it's wrong and you might be opening yourself to personal liability. Instead, it's very broad. And it just means that any reasonable person would have made this decision. Okay, next. So this is nuts and bolts. How do you exercise the duty of care? This is things you are already doing, I'm sure. So attend meetings and be sure to take your time when you're considering decisions and look at all the different angles. Prepare, read any reports that come to you, ask questions, and exercise independent judgment. That really happens sometimes where everyone ends up just saying yes without really thinking. So it's really important to kind of take half a step backwards and think about, does this make sense for our organization? And when the next one, record board proceedings, doesn't literally mean like get out the video camera. What it really means is take minutes and keep a record of what goes on in the board meetings. And last one is just do not give approval without taking time to think through the different options and what's best for the organization. Okay. Closely related to this duty of care is something that is called the business judgment rule. And basically what this means is that if there's a bad turnout and people are upset and they are unhappy with the board and they file a lawsuit or something, there's a lot of protection for the directors. And basically, everyone makes mistakes. And what the business judgment rule says is that as long as the directors were paying attention and reading reports, that you assume that they were making their best judgment at the time. And again, it's okay if a decision ends up to, for example, lose money for the organization, for example, as long as the directors were reading all the reports and making the best decision based on what they had in front of them at the time. Okay, next, please. The duty of loyalty. So basically what this means is, the shorthand, don't steal. So a director needs to act in the best interests of the organization, and needs to set aside personal benefit and personal interest. And instead, when you are making decisions as a board member, to make sure that you have the organization at the top of your head and you're wearing the organization hat, so that you are really thinking on behalf of the organization, acting in behalf of the organization instead of on a personal level. Okay, next. Part of this, closely related, is the idea of conflicts of interest. So we get conflict of interest questions really quite often because they come up all the time. And I think one question that comes up is sometimes people assume, I should say, that conflicts of interest are a really bad thing or that they're prohibited. But in fact, there's an IRS kind of procedure for conflicts of interest happen all the time, and there's a procedure for how to deal with them when they do. So basically, if one director, if the organization is going to have some kind of arrangement or agreement or contract with another organization, and the director of the nonprofit is wearing two hats and also has a relationship with that other party, then that director needs to disclose that potential conflict to the other board members. And then the other board members decide whether that conflict is actually a problem and enough of a conflict that that director should step aside and not vote. Or the board may say, you know what, we see there's an overlap, but we think that you still can decide keeping the nonprofit at the top of your mind. So we don't think it's a problem. So these happen very regularly. And as long as the organization is the director discloses that conflict of interest and the board considers it and you make a note of it in the record in your minutes, then it's good. So part of this is hopefully each of you all your organizations have a conflict of interest policy. And we always suggest once a year at election time during your annual meeting, pull out the conflict of interest policy, just kind of review it with everybody. And then you might have a version that has at the bottom a list, a page where directors can write down any other organizations or businesses that they have a connection with that may be a potential conflict of interest, just that people keep it at top of mind. Okay, next, please. And finally, the duty of obedience. So this basically means you need to keep up with your paperwork. So don't slack. Be sure that you are maintaining your corporate status. If you're a Chapter 181 organization, that you're filing the IRS annual report. That's the Form 990. You may have charitable organization registration. So basically, keep up with all of your paperwork and keep good records that you are, and that will allow you to comply with the duty of obedience. Okay, next, please. So finally, the part that we really want to hear about is what is a director's protection from liability? Okay. So the basic idea is that for any officer or director, and this also includes employees and volunteers under Chapter 181, as long as these individuals are keeping up with those duties, they're acting on behalf of the organization, they are paying attention, they are complying with all the paperwork, then they are protected from personal liability. Again, that's a huge relief to know that and to have it clearly spelled out. And again, that personal liability is lost if a director is not meeting those basic duties of care, loyalty, and obedience. Next, please. So here, the moment you've been waiting for, the actual law with the citation. Again, this is a summary of it, but basically, again, as long as the directors are complying with their duties, then there is no personal liability. There are, of course, exceptions. So as a director, if you're violating a conflict of interest, then that personal liability shield can be lost for violating criminal law, or if you're getting some kind of personal benefit from a transaction, then that personal liability shield will be lost, or if there's willful misconduct. So there's all the ways that you lose that protection from personal liability. Okay. Finally, the question of indemnification. So nonprofits are required to indemnify their officers and directors. So what that means is, if a person is unhappy with something an organization has done, and they file a lawsuit against the nonprofit and against the directors in an individual capacity, then the nonprofit is required to defend the individual directors. So if there were a lawsuit, then the nonprofit would be responsible for those costs, and the cost of defense. And that is a reassurance to the individual, of course, and it does mean that cost of defense could add up pretty quickly for the nonprofit itself. So next slide, please. That leads us to insurance, and the probably the insurance that most nonprofits hear about the most and most commonly get is directors and officers insurance. And basically what this does is, if someone does file a lawsuit against a nonprofit and its directors or officers, then the directors and officers insurance covers that cost of defense. As you can imagine, even if there is no personal liability against a director, just defending that lawsuit can be expensive. So that is what the D&O coverage will cover. And other things that are very common among nonprofits that we help out is commercial general liability. If you have any kind of activity where there are other folks coming and you're have events, and there could possibly be even like a slip and fall kind of case, or anything like that, the commercial general liability will help cover those kinds of accidents. And workers' compensation, we can talk about more, but basically that's if you have 3 or more employees, whether they're full-time or part-time, then you're required to have workers' compensation. Next, please. And finally, this is the scary part. This is one thing to be aware of, that all this protection from liability that we've been talking about there's a huge exception, and that has to do with employment taxes. So if a nonprofit has employees and fails to pay appropriate income and payroll taxes, then the directors themselves personally can be held liable for those taxes. So it's very important when you're on a board and you have employees to make sure that those employment taxes are getting filed and paid, to make sure that that liability does not, that the directors are not opened up to that kind of liability. Okay, last one, please. And that is it. And I will keep it short to leave plenty of time for questions.
Yeah, thank you so much for that, Jessica. That was a great overview of liability issues. So maybe we can take a few minutes to take some questions. If you could type those in the chat for now. Later on, we'll go to more of a hands up type deal. But for now, let's keep the questions in the chat for Jessica. Actually, Dan Zimmerman asks a good question that I was going to bring up. Nonprofit category covers lake associations. What about lake districts that are government entities? So how do the liability protections as a municipal governmental body, how similar are they to what you talked about for associations?
You know, I don't have any direct experience on this, and Mike, you probably do. Lake districts are they're codified under a different statute, Chapter 33. So there's no specific protection from liability named in Chapter 33. So I'm not sure how that's played out in real life. But I don't know. Perhaps would the municipal insurance policy cover the district because it's part of the local government?
Yeah, and maybe we'll put a pin on that and let Nathan take a crack at it when he comes on too, and then we can discuss that more at the end. But that's a good question from Dan. Someone asked, is there a model conflict of interest policy that's out there anywhere that can be looked at?
Absolutely, and I'll try to throw one up in the chat. In a little bit, I'll put one up. There is a standard IRS one, is the one that we recommend for most organizations. It's sufficient, and it just sets out that procedure that I described. So I'll try to put a link in the chat here in a minute.
The questions are beginning to come in. So Laura asks, if someone is injured while recreating on the lake, can they sue, and could the association be held liable or be sued? Is that where the general liability or D&O coverage comes in? So I think she's talking about just someone on the lake for the weekend, not necessarily at an event, is the way I interpret the question.
Interesting question. There would need to be some kind of a connection to, like, if the lake association installed a pier improperly and that's what fell in, then perhaps I think there would have to be some kind of you'd have to be able to connect the injury to the lake association in some way. So that would be, of course, the devil's in the details, right? So, but that would be my first reaction. Is it really? Yeah, it depends on if you could connect the injury to something that the lake association, provided
Sure.
or set up or something.
Yep. Kind of a follow-up question to that. Someone asks, any additional concerns regarding liability for associations that install aerators in the lake? So it could be aerators, but if the maybe that's sort of the same kind of instance as if the injury occurs at a pier that's owned by the association. But if there are improvements that are put into the lake by the association or the district, could they be held liable?
People can sue for any reason, really. People don't sometimes need very much to do that. So if a person were to sue, of course you can sue a nonprofit. They are a corporation. So yes, a nonprofit and a lake association can be sued. Lake district, we'll have to think about that one a little bit, but certainly an association. That's exactly where the commercial general liability comes in, is to protect it, to defend for any kind of a lawsuit along those lines. And the directors and officers coverage comes in to cover the directors if they were to be named on a personally in a lawsuit. Yeah, so certainly, I mean, people, even if someone files a lawsuit that has no basis, you still have to defend it. So that's kind of the frustrating thing. So if someone's unhappy, there's an injury that takes place, then they're going to look for anybody who might be responsible and put everybody's name on the list of defendants.
Yeah, that's a really good point. And I'm sure Nathan might have some thoughts on that too
Sure.
in a moment as to why D&O insurance might be a good idea, and if you think you're not doing anything that you are likely to get sued for. This is actually
Go ahead. I was going to say, one thing that the aerator question, or even the pier question, kind of brings to mind, and maybe it's different when it's lakes and there's open access, but you hear of waivers. So what about waivers? Will that be helpful? And I'm not sure that waivers are certainly useful if you have a specific event that people are signing up for example, and they can do a waiver as part of the registration. It might be hard for lake associations to even present a waiver. But waivers are tricky. They're very tricky because they don't hold up in court all that well. So the waivers are construed by courts to be in favor of the person who gets injured. So the idea is, in order for a waiver to stand up, the language has to be very clear, and has to be very clear, like what is being waived, and the font has to be big enough, and there has to be a chance for the person to negotiate. So really, waivers are not really the answer, although they might help make the case that that the organization warned people about possible dangers, but they're not the magic bullet.
The other question, and I've actually had this question asked of me a couple of times this year, and I've never seen this one before, so I find it kind of interesting. The question is, if a group, say, testifies at a zoning board hearing, or advocates for a particular rule or ordinance. The testimony is clearly in opposition of the developer or whoever is a proponent of the issue that's in front of the governing body. If the zoning board turns the developer down partially on the basis of that testimony, could an organization be held liable for any kind of its advocacy work, I guess?
That's interesting. Yeah, I think advocacy is the key word, right? Because so a lake association could be a 501c3 or a 501c4, and 501c3s, right, can do a limited amount of advocacy. And the question is, would this be advocacy? And advocacy, the general definition is, when you think of it with legislation, like at the state legislature, if you go in and say, this bill that's been proposed is great and we really want you to pass it, and you talk about specific legislation, then that would be advocacy. And here, I think this probably would count as advocacy, because the zoning board would be an official government body, and you're talking about a specific decision rather than just educating about lakes more generally. I'm not sure what the liability, I guess the liability would be the developer would lose money, and by not being able to develop a certain piece of property or something. So gosh, I can't imagine that. I think that would be a really, from a lawsuit perspective, that would be a very hard argument to prove that the zoning board wouldn't have already turned down the developer, for example. But as far as, so there's two things. One is the liability question is a developer could certainly sue if they wanted to. I think they'd have a hard time winning that argument. But again, if you had insurance in place, it would cover that kind of defense. Separately is the question of, is this advocacy that the IRS might be tuned into? And I think it probably would be, but I can say that 501c3 organizations can do a little bit of advocacy. An insubstantial amount of advocacy is the language. And if you're a 501c4, you can do even a little more. So, or actually quite a bit more, as long as it's not your primary purpose. So I guess I think that if I were a lake association, I would, and this is really important to my mission, to protect green space, then I wouldn't hesitate to do this, to go in and give testimony if it really supports my purpose and it's important. But I think that a developer could be unhappy and could choose to file a lawsuit. I just don't see how they could have much footing to be successful.
Yeah, I think there's, it's not the lake organization that's making the decision, and really all they're doing is expressing their own First Amendment rights to free speech and to participate in the governmental process. So I don't think probably there could be liability there. And you're absolutely right about where the problem could come in is if there's too much advocacy being done by an organization. And it is, you are limited as a C3, but it may not even be as limited as you think. Wisconsin Lakes is a C3, and as long as you keep within the IRS guidelines, you should be okay. We'll be doing a webinar at some point in the summer that will deal with lake organizations and advocacy and these exact sorts of questions. So you can watch for that coming up in a month or two, hopefully. I think we'll save the rest of the questions. I see that Eric posted something specifically about aerators. So if you have questions about that, you can look at the chat and get some information about that. And there was a question about lake districts and workers' compensation, which I think is a perfect segue into Nathan, because we were discussing exactly that issue before everyone came into the session. So thank you, Jessica. If you're able to, please do stick around we'll do more questions at the end. But I'd like to turn things over to Nathan. If you have any introductory remarks or anything you'd like to react to the questions that were already asked, Nathan, feel free to do so, but the floor is yours.
Thank you very much. Well, there's a lot to digest there. Jessica hit a lot of great points. And I think what I'm going to do is I am going to, let me start my video here. I'm going to go through one statement. I'm just going to say it's going to be the heart of what we always talk about. And Jessica said it perfectly. The whole idea is to minimize your risk. I think we can all agree that insurance is probably not the most fun thing that any of us have to deal with. Can we just all lay out that, just all agree? But it is part of the equation, be it a lake district, be it a lake association. There are needs for it on either side. The products within are going to vary on your operations. They really are. When we talk about directors and officers, when it comes to Wisconsin lakes associations, it's a little bit different than it is lake districts because of the municipality factor on the lake district side. With the lake associations, the reason we got involved with the Wisconsin Association of Lakes was on a directors and officers policy, because the language in those policies typically did not include volunteers of associations. And the policy we put together, it did include volunteers as members or insureds under that lake association. Now, when we talk about directors and officers, think about being protected for the decisions you make, okay? You as a lake association decide to restrict boating, I don't know, in the month of July, which causes property values to decline, something along the lines of there where citizens don't like the decisions of the association. That directors and officers association policy is designed to protect you for the decisions you make as an association. However, when we talk about things like installing a pier, putting in aerators, putting in buoys, that is something that is closer to a general liability, okay? Thankfully, I should say fortunately enough, I actually live on a lake district. And so I get to see one in motion in real life. And let's say my lake district decided to put in buoys and they put it in a spot where I actually hit something underwater. That decision they made is not a directors and officers decision. There's actual damage to persons or property. So that's where liability would come into play. I will say that in my years as an agent, and I've been an agent for 19 years now, about going on 9 with Horton, I found that the best place to get your liability is your local insurance agent in your hometown. They have access to a lot of, I would say, smaller insurance companies. I work for an independent insurance agency, but we just don't have some of the insurance carriers that we've seen offer really low premiums on the general liability side. The directors and officers side, it's a little bit harder to find those policies. That's why we created the master policy for the Association of Lakes. But on the liability side, a lot of places can do that, and they can do it far less than something that I can. I'm always happy to guide people. I've seen a lot of budgets on the association side. You don't want to eat up your budget on the spending it on insurance. But if you're putting in piers, if you are having picnics, if you are performing functions as a lake association or district, I'm going to highly suggest you look at getting a commercial general liability policy. The directors and officers, I think, is pretty, I call it table stakes. You should be getting that no matter what, because while every lake association and district may not be putting in piers and performing functions, every single one of you guys makes decisions in some way. And as members of those boards, you want to protect yourself in the event that something goes wrong. Now, there are big differences. There was a question a little bit ago about the liability for association versus a liability for a district. In the state of Wisconsin, under statute 893.8, members of a lake district, which are considered a municipality, are protected under state statute caps and damage limits. And currently that's 50,000 in damages that can be, I guess, maximum awarded in the event of an incident. So there are differences and protections on the district side. To my knowledge, and Jessica spoke much more about this, the association side, I don't, I'm going to defer back to someone like the expertise of Jessica, who knows more about the nonprofit association protections, if you will. But on the municipal side, 893.8, which is claims against governmental bodies or officers. I'm reading it on my screen so I don't mess it up here. Officers, agents, or employees, limitations of damages and suits. It does not mean that somebody can't place a suit against that district. We all know they can. However, there are limitations for what they are allowed to receive. Now, these are state limitations. We have seen if a claim goes to federal court, those statutory caps do go away, but there are caps in place for in the event for a lake district. I do often see a much more robust insurance package when it does come to a lake district than a lake association. But in either case, look at your operations. Always go back to your operations and to determine how much and what type of coverage you need. If you're a lake association that only makes decisions, maybe you don't need general liability. But maybe you do own equipment. Maybe you do own property. Maybe you own a garage where you can keep a weed cutter. Maybe you have an automobile. Highly unlikely, but still, anything that you have as exposures of your operation, you want to make sure you take into consideration with your insurance policy. Now, the same goes with lake districts. Very common. Those are, I guess, in my opinion, much more package policies, if you will, are much more readily available for municipalities and lake districts than they are for associations. So a lot of the coverages that we could build a la carte for associations, they can be purchased typically in a policy package for a lake district. And municipalities just have much more, the protections, if you will, I know insurance companies feel much better about. But lastly, I'm going to bring up the question, do directors of a lake district need work comp? The answer is yes. Even though you may not be paid, the state of Wisconsin looks at it as you are an employee, if you will, and there's a payroll assigned to that person, that number, each person on the board. And work comp is necessary in the state of Wisconsin. I'm not saying everybody purchases it, but we do consult them that they should. I think let's open it up to questions if you're okay with that, Mike. I'd like
Definitely.
to be less about me and more about, hey, what do you guys have what do you want to know about you?
There was a question, and for the purposes of our topic, are lake districts and sanitary districts the same? And I don't know exactly the enabling statute for sanitary districts, but
Yeah.
as far as I know, they're pretty much the same. So I would think for insurance purposes, they would be.
Yeah, I mean, I do cover, my specialty is I work in public entities. And while their functions are not the same, they are both considered public entities. A lot of the package components of their policies are the same. There could be a pollution element that we look at. For Lake District, it's application of chemicals. For a sanitary district is how do they treat their water? How do they dispose of their waste? Things of that nature. But different functions, but yet both municipality-based organizations.
Great. And we can open this up to general questions, so it can be for Nathan or it can be for Jessica, and they can obviously both respond to things. So we've got a few questions in the chat that I'll go through, but if people also at this point want to raise their hand, which they do, is that in reactions, Eric, or is that on the participant screen? I can never remember. It's on, if you go to the,
Reactions.
reactions down where you would have clicked on to get into the chat, you can raise your hand. And then it'll show up in our, you can see on the participant list, it's shown up as Eric's raised his hand. So, but this maybe could go to Jessica, I guess. Lynn Wiggins asks what I would call a wonderfully classic law school kind of question. If the association or district decides not to carry general liability insurance, can the directors be held liable for that decision and thereby responsible for any damages incurred by a plaintiff who is injured by something?
Oh my goodness. Lynn, you should be a law school professor. That's a good question. Again, going back to if the directors themselves are exercising, they're using their best business judgment and they are otherwise, upholding their duties, then if a reasonable person could decide not to carry the general liability insurance, then they can't be personally liable. Yeah, so I don't think so. I think that would be, there probably is some strange set of circumstances you can imagine where that would be the case, where they'd be held liable for those damages, but I don't think so.
All right. Charles asks, do lake associations need workers comp coverage for clean boats, clean waters, paid volunteers? So these are the, so I guess we could ask the question of, do they need it for paid staff or do they need it for volunteers who are working on behalf of the organization? So these are the people that are working at boat landings, providing boater education on aquatic invasive species, cleaning off their boats and doing survey work and such.
Well, if they're volunteers and they're not getting paid anything at all, no, they don't need it. The Work Comp Rating Bureau in the state of Wisconsin they have a 9-point test whether to carry, whether workers' comp should apply. And typically 3 employees is where it starts. And then it talks about seasonal employees and how much, I believe it's $500 in wages per quarter. A lot of times you don't get to that number. But if you are exceeding what the state says is required, or when it's required to carry workers' compensation, you are required to carry it. The best thing I can always ask is ask your insurance agent, be it myself or whoever you're working with locally, because in Wisconsin, it's very clear cut on when you need to have coverage. All the rules, regulations are overseen by the state, the Workers' Comp Rating Bureau.
Great. Nathan, what about having an event liability policy for a single event rather than a general liability policy?
This is a very common question, and a lot of times it is more cost effective to have a general liability policy than it is to have an event policy. An event policy, while having less coverage, if you will, or I'm sorry, less premium, it's usually not a whole lot less than a general liability policy. It really isn't. And the coverage limitations are very, very minimum. However, if that is all you truly have, then I would say it's definitely get at least an event liability policy. It's better than nothing, especially if that's the only thing you guys really do. If there's alcohol involved, though, like a association picnic, those typically it's better to have an association general liability policy overall.
Okay. Melanie says, and would my homeowners cover that liability? I'm not sure. I wasn't paying attention when that question, what we were talking about when you wrote that, Melanie. If you are willing to unmute yourself, you can go ahead and fill in the details exactly what you were talking about there. We may have answered that question already, or feel free to type more in the chat if you would prefer.
2 or 3 questions ago with
So is that in regards to the complicated law school-ish question?
Yes.
Okay.
I'm not gonna, I can't say for certain that a homeowner's policy would. I haven't dealt with homeowners policies in a long time. If you're an association member, it's more likely that an umbrella policy on your homeowners or personal insurance would cover something like that. I would find it less likely to cover something, an umbrella policy, less likely to cover an event like that if you were on a lake district, because of the way they're organized and the way they look at association versus government entity. But I can't be 100% either way.
I think that makes sense. And either one of you, if say that your homeowner's policy covers your liability for something, that doesn't necessarily mean that that your insurance wouldn't go after the lake association because they know that the lake association is statutorily required to indemnify the director. Does that make sense?
I think it does, yeah.
I don't know if
I think for sure. I think you're right, Mike. The homeowner's insurance would certainly bring in any other responsible insurance company they could find, and I think that certainly they would bring in the lake association insurance company.
The problem I see is not a lot of lake associations purchase the general liability portion, which is where the majority of the damages come into play. It's unfortunate, but that's with the people I talk to, the directors and officers is one thing, and I think it's often confused with general liability. Like, I don't want to get sued if I'm on the board and so slips. It's actually, you're on the board, the decisions you make are directors and officers, but somebody slips and falls, that's general liability because it's injury to persons or parties. So unfortunately they are going to come back and try to indemnify themselves, subrogate, but at the end of the day, they might end up covering it as an associate or homeowner's umbrella policy.
Right. James asks a question that or makes a comment that we frequently get. Local insurance carriers don't seem to be able to handle general liability for lake associations. They just treat them as homeowners and association, which doesn't seem right, doesn't always cover the right things. I've heard sometimes that it's hard for associations to get liability coverage for that very reason. I'm trying to find agents around the state that understand what associations do and have been able to find coverage for them. And I have a couple, and you can feel free to contact me to talk to them. But that is my at least anecdotal experience from what other associations have told me, is that it's sometimes hard to find the right coverage for general liability.
I agree. We had policies for quite a while, and I would say about 2-3 years ago, the market hardened on them big time with our carriers, and minimum premiums were skyrocketing. Typically, when I get a call for somebody looking for general liability, I'll just do a Google search of insurance agencies in their area. I'll look for somebody that's maybe a multi office, somewhat of a middle-size insurance agency, if you will, that's going to have access to the West Bend Mutuals, the Mount Morris Mutuals, the Germantown Mutuals, Acuity, I would say smaller local Wisconsin Mutual, Badger Mutual, smaller insurance carriers that are familiar with the state and have seen these risks before.
I know there's one agent out of Rhinelander who I actually invited to also be on this webinar. She couldn't make it today because of a conflict, but who has worked with a number of associations, at least in the north central part of the state. And I was hoping she could come on and talk about that very problem of having to figure out what it is that needs to be covered, and getting the underwriters to understand, what having people come in and do weed harvesting and things such as that. So that actually leads to another question from Rick, who asks, is there a liability issue when doing things to improve lake habitat? So installing cribs or fish sticks, doing stocking of fish, all those sorts of things. So either one of you, if you have thoughts on those sorts of things.
I have not seen any. I don't feel like their agent, or I don't feel like there's any liability when you're doing improvements as a district or as an association. And if something went wrong, it would be very hard, in my opinion, for somebody to claim damages. I think isn't the whole goal of associations and districts try to improve what you have? And so now look, anybody can put a claim in, Rick, but I would say there's a very, very low chance that anybody's going to get anywhere.
I agree with you, Nathan, for sure.
And Jessica, I'll ask too, in any sort of situation where there is a question of whether the organization is liable, whether it's maybe this is less in the case of a district because it's a municipal government, but in the case of an association, if it's known that the association doesn't have a whole lot of assets, would you say that it's less likely that that association is going to get sued because the attorneys that the potential plaintiffs would be consulting with is
they know there's no
right,
right.
there's not much to get. Is that a valid assumption on my part?
I think that's very practical and probably real. And to tell you the truth, what we kind of joke about in this case, I think you're right that there's a lawyer's like, well, what's the point of going after this lake association that has a few $1,000s in assets or whatever? But so what I find interesting is that often you would think that people wouldn't sue a nonprofit because there isn't much money to be gained. But honestly, the most suits that we see, like the most litigation that we see, has to do with power. Like a person will get removed from a board and will come back and file a lawsuit, something about the board not following proper procedure and removal or something like that. So it's really, we actually see more about power than about money that come into our realm.
Eric posted some stuff on liability around fish sticks and habitat. Dawn asked regarding weed harvester operations, what types of coverage might be needed? So this is, operating larger equipment, might be more likely that a district would have it. But any comments on that, Nathan?
General liability, number one, you got to have it, even if it's not owned by the actual district themselves or the association themselves. If the district or association owns that piece of equipment, I typically see what's called an inland marine policy or portable equipment that covers that specific harvester. And you can insure it for whatever replacement cost you want. Those are pretty easy to put together. I typically will see an auto policy as well. Some districts or associations will own a vehicle and a trailer to take the items away, take the debris away from the weed harvesting operations. But aside from the general liability, the next most important item is going to be workers' compensation. And I can't stress this enough because we actually, I believe it was last year, maybe it was 2019, we actually had a gentleman pass away in a weed harvesting operation and workers' comp paid out on it. The weed harvester did flip over and pin the gentleman underneath it. So you want to make sure you are protected in that event. work comp, the inland marine, and the general liability should something happen to a third party.
Great. I did find Tracy Ritterbush's name and email. She's the insurance agent that she works for Deal Insurance Group, which I'm pretty sure is in Rhinelander. And I know she's, as I said, been able to help some associations in Oneida and Vilas County, at least. And she's said that she's willing to talk to other people, not surprisingly. So I feel pretty confident. There may be others out there. And if anyone else already has agents that they work with and would like to, go ahead, feel free to post their information in the chat. We're not claiming that any one insurer is better than another or anything like that. But if we know people that have worked with associations, that would be great. Associations, especially.
I mean, especially when it comes to general liability insurance, I'm happy to send them to somebody that the carriers I have are not affordable. I don't even want to say it. I don't even want to like recommend them. So I'm looking for options all the time too.
Right. Yep. Eric, I don't know the answer to this, but you might. What are the insurance requirements that are, if any, that are when you get a surface water grant for doing things? Are organizations required to carry insurance in those cases?
Don't believe so. Tell me where this question's coming from.
My own head.
Okay. I don't think so. Again, kind of like the fish sticks proposal that was passed in 2016 and signed by the previous governor. When issues like that come up, usually it's not too hard to actually, because so many lake districts and lake associations are working in the public interest, there's really a lot of effort to try to clear the path for them to do things that are in the public interest. And so if in this case, someone just really wanted to clarify that placement of trees on the lake bottom and along the lake shore didn't create a liability or a hazard risk, then they went ahead and just changed the law and made it clear that if you're doing it under these purposes and you comply, you sort of stay within the bounds of what the general permit for fish sticks describes, then you're fine. This doesn't mean that you can just take a tree and dump it out in the middle of the lake, call it a fish stick, and not have any liability for what could happen after that. The idea is that you follow some rules and regulations. You stay within reason of what's permitted around lakes. So I think I have not heard of an example where a grant implicated a new need for insurance. Get some more questions getting posted. One of the questions that comes up a lot has to do with clean boats, clean waters. Nathan, you're probably familiar with this program. It's the idea that we can have boat landing personnel that can be volunteers. They might be paid. Oftentimes they're paid. Who has the workman's comp obligation for those employees? And similarly, how do lake groups address unemployment insurance? How do they make sure that they're not getting into trouble if they're not paying unemployment insurance?
Well, unemployment insurance is more of an accountant-based type question. So I would say reach out to a payroll specialist or somebody in that regards. When it comes to the work comp obligation, if you're exceeding that $500 per quarter on wages, it is up to the lake association or district that is ultimately hiring that intern, because typically it's hired by the association or district themselves. Is that how a lot of them are set up? Because that was my experience.
That's correct, but there's also like complicated ways that people do this. So one, Bob Nelson is asking about when, say, UW Oshkosh is working as sort of a middle person with the lake groups. My guess is that UW Oshkosh is running the payroll, and Bob, you can clarify that. But if UW Oshkosh is actually running the payroll and issuing the checks, then it would seem that UW Oshkosh would be including those employees under their workers' comp.
That'd be a great question to ask them. My guess is it's going to be in the agreement between the organizations and UW Oshkosh.
Yeah, so Bob's answer was that they do run the payroll. I mean, I work at a university, and I know for a university of the size of one of the campus comprehensives, adding a couple more student employees does not really change their risk profile and their insurance costs. A lot of, I think, the UW campuses are actually self-insured. I mean, they don't really have an insurance policy. They just figure they'll budget for whatever expenses might come along the way. For a small lake association or even a small lake district, it can be sort of a big leap to take to say, okay, we're going to employ people now. And now we do sort of take on this workers' comp obligation. At the same time, maybe Nathan, you can talk, and I've had to dig into this myself. Workers' comp is not exactly a very expensive policy, and there really isn't any shopping around that you do, right? People just get classified, and then it's a state-run program.
Right. Yeah. All the rates are set by the state. It's all based on payroll, and there's not a lot to it. Most of them you're going to see is the minimum premium of $900, and that's going to be it. And this is the first time I'm hearing about the UW Oshkosh, doing this the way they're set up. My guess is if you're paying a lump sum to UW Oshkosh, more than likely that isn't going to include, UW Oshkosh is covering the work comp, and the Lake Association or district would not have to cover it. I'd be always happy to look at an agreement and just double check, but if don't pay for it twice if they're covering it. It's, because even if your exposure is $200, the minimum premium is still going to kick it up to $900. So even $900, don't spend $900 if you don't have to. It would be my opinion.
I'll bring Jessica into this. Jessica, I've heard some organizations have attempted to get around the problem, even with Clean Boats, Clean Waters volunteers, by declaring them not employees and calling them contractors. Can you talk a little bit about the problems that can arise from those sorts of distinctions?
Oh boy, do we have another hour?
Yeah, I was going to say, I opened up a Pandora's box there, but
the short version is, as an organization, it is so much easier if you have independent contractors, right? Because you just write them a check, and then they're responsible for taking care of their own taxes. The problem with that is, it's simple, and that would be the way to do it if you could just choose. However, a person who does work for an organization is presumed to be an employee unless you can prove otherwise. So there's actually a test for tax-exempt organizations that you go. It's a multi-factor test to figure out the basic division is an employee is someone that is supervised. You tell them when to show up, you give them the tools, and they're working at your direction, versus an independent contractor where you say, I need this project done by the end of June, and then they just go and do it. So that's in really broad strokes, that's the difference. Of course, an employee, the employer is responsible for the payroll taxes and the workers' comp and all those things. So it really is a case-by-case analysis. But I would say that if the person is being directed, then very likely they're an employee, and they are presumed to be an employee also.
An important consideration is to have in mind. My advice is always to err on the side of caution, because you can end up with a lot of fines if you get that wrong. That's
right, and there's been more enforcement in this area too by the state.
Right. Did I miss any questions in the chat, Eric, that you noticed? I don't really see any others. So,
Mike, I'm going to put in the chat, the Department of Workforce Development has I'm going to put a link here. It's called a 9-part test to determine an independent contractor for workers' compensation.
That's great. And I would say that would be, there are a couple different tests, but the workers' compensation one is the most stringent. So that would be the test to use if you're trying to decide if an individual is an employee versus an independent contractor.
Great.
And someone did have a question about, is there a specific agent in Racine County that maybe works with lake districts? And I don't know if we have a good answer to that. Oftentimes I advise lake districts to network with each other, to reach out to nearby lake districts and ask them what their experience has been with insurance, because they can often be the best sources of information. And me being in Stevens Point, Mike being in Sun Prairie, it's really hard for us to have any sense of what's going on all around the state. But usually there's something locally that develops around insurance. And if you're a lake district, oftentimes you can also communicate with the town that you might be in and just ask them about their experience with insurance as well.
Otherwise, if anybody reaches out to me, I'm happy to guide you. I'm on a Stevens Point as well. And so I'm happy to guide you guys according to where you are.
Great. Actually, a good question just came in from Peter. He says, our association isn't organized, owns no assets, really deals more with common interests. What kind of risks do they have? I'm going to assume by that he means that they're not incorporated, Jessica. So talk a little bit about, as an unincorporated association, what kind of liabilities and protections they might be facing.
Right. As an unincorporated association, the statutes do not spell out really anything as far as limiting personal liability, which I would say is why a lot of groups, have been unincorporated for years, because that's just the way they started, and they started quite informally. But over time, they'll decide that they want to formalize and to incorporate as an actual, recognized non-stock corporation, to get those very explicit protections. And really all that the unincorporated association statutes say is that just by virtue of being a member of an unincorporated association, you aren't necessarily liable as the corporation, the association itself. So for what that's worth, and that's a little bit helpful. But it means that there is this association and it is a standalone thing, but it definitely does not spell out the personal protections. So often it depends on if there's no assets and you're not really doing much, then maybe feel comfortable with where you are. You could also choose to put on your something to discuss. Do we want to think about incorporating as a non-stock corporation, just to get that personal protection from liability?
Great. And my recollection is that it doesn't take much to be deemed an unincorporated association, right? It's only like 3 people acting together in common purpose or something like that.
That's almost exactly the definition. That's right. Yep.
I remember my statutes well, I guess.
Yep.
Eric just put in the chat, pointed out, and my producer Sarah had pointed out to me too, that there's a typo in my slide that I just shared. It's not May 17th the Lake Association capacity training is happening. It's May 27th. But you can see on the slide what our upcoming Thursday topics are going to be. Certainly, we normally have this slated to go to anywhere no later than 5:30. So if you've got more questions, you can keep asking them. But I've put the contact info for everyone up, and our next week's meeting on May 13th will be a Lake District Treasurer training. So what treasurers need to be thinking about before the annual meeting. Any other questions for Jessica or Nathan?
Yeah, this is Larry Beaumont. Could I ask a quick question?
Yeah, go ahead, Larry.
Yeah, Nathan, so if I kind of understand your high level description there, I'm on a lake district. So I think what you said is that even if we don't have employees or are not paid as a board member, that we still should have workers' comp. I think you said that, didn't you?
Yes, I did. Yes.
Okay. And then should we also have this director and officers insurance in addition? I know right now we have general liability and we have an auto liability policy, but then would we also need this director and officers insurance?
In my opinion, absolutely. If you are a lake district and you are a taxing authority, absolutely. Because that protects you as an individual for any decision you make as a member of that board.
So, like when I read People of the Lakes, the guidebook for lake districts and associations, it almost inferred that we were kind of protected by the state, but listening to you, it sounds like we're not.
I mean, there are statute caps, don't get me wrong. There are protections in the state being a part of a district or part of a municipality, but there's still, it's still a litigious society, and the cost to defend can be quite expensive, even in the event that nothing is awarded to a third party. And so many times that's the part that people are really buying coverage for. It's not necessarily for how much, you know what, Larry, you hurt me, so I'm going to sue you and I want $50,000 in damages. That's harder to get than racking up $100,000 in legal defense costs just to prevent, just to protect you in the event of any claim that comes on board.
Okay. Well, I'll be calling you. What's a good time to call?
Anytime.
Okay. Thank you.
Yeah, and again, I don't mean to be doom and gloom, but it's unfortunate that we have to talk about coverage for all these different aspects. It's just the way things are nowadays. The very first part of risk management of any organization is don't risk a lot for a little. The premiums that you're offsetting by buying this coverage, they pale in comparison to protecting yourself for what could be a claim. Chances are you're never going to see a claim. Unfortunately, they do happen, and that's what you're purchasing coverage for. And being a district, you do not want to actually have to, you could spread that risk of a loss that's not covered amongst your membership base or your tax base. You don't want to do that. I think the members of your district would much rather have their funds go towards proper protection for the district that they are a part of.
Okay, it's good advice. I'll be calling. Thank you.
Thank you. And to Mary's question, I am highly recommending D&O for associations as well.
Yeah, it's this same sort of issue. You just don't know who is going to sue. And if they do, and if they sue your directors or your volunteers, then they are, the organization becomes liable for that defense. So even if it's a frivolous suit, there's still the potential of, the organization basically is responsible for the attorney's fees for those directors. And so that's what D&O kind of helps cover.
I saw a question earlier that was asked, and I apologize, I missed it. The question was, if my liability caps are $50,000, why would you not just buy a $50,000 policy? And it's exactly what you just said, Mike, is the cost to defend. While we know what the caps are, we don't know what the cost to defend is. We do not know if the claim is going to go to a federal court versus state court, or maybe the statute caps disappear. So typically the minimum I see is $1 million in liability on the directors and officers and the general liability side. And in the realm of insurance, that's kind of the starting point anyways. Premiums are very reasonable considering that's where we start. So it's not like it's going to cost you $20,000 for $1 million. That's not how it works. So if you see the million, that's just kind of where most commercial insurance companies will start. Some will go 500,000, but most are going to be in the million and up range.
Can I ask a question that's an insurance question, but not necessarily liability?
Go ahead.
What are the, what's your recommendation for things like bonding the treasurer or crime policies or just anything like that? Any general observations about that?
Yeah, I do highly recommend a crime policy. I often see a lot of districts and associations say, we won't worry about that too much. A district, I think it should be mandatory. Ideally, you could be bonded. You should be bonded. It's not statutorily required as it is a town, city, village. But I still recommend it. And if nothing else, if monies are being handled as an organization, I think a crime policy should be included every time. Okay, Mike, you know this, and Eric, you know this. How many associations and districts deal with grant writing? Many policies will have a failure to perform duty clause within their crime coverage. If we've had instances where municipal, let's say clerks, will not turn in grant paperwork because they're upset with the board. And there was coverage that could be found in those cases because the district missed out on monies by the intentional act of a clerk in this matter. And so that can be found typically under a government crime policy.
Thank you. Yeah, that's helpful.
I have a question.
Go ahead, John.
Earlier, a gentleman mentioned getting permission and actually coordinates for buoys from the DNR. Is there a specific procedure for doing that? And if so, where would I find it?
I think I linked that in the chat. So I would recommend following that link. It was quite a while ago. Scrolling up to find it. It kind of falls under boat ordinances. So when you click on that boat ordinances link, I'll put it back in the chat just so you have access to it. The second thing it talks about is water. They're called waterway markers. And that includes buoys. And so there's another link in there that just says guidelines for creating local boarding ordinances and placing waterway markers in Wisconsin waters.
Okay. Thank you very much.
You bet.
Other questions?
So I put that in the chat now. It's the bottom link there. It's a DNR link.
Got it.
I guess I'll reiterate something Nathan said. And it's really hard, for either myself or Mike to answer this question kind of with a straight face. It's when people say, do you mean every lake district has to carry unemployment insurance for the Board of Commissioners? And the answer is yes, that's what you're required to do. But then as Nathan sort of hinted, it's also not uncommon for a lake district to not carry that policy. Nathan, what, and the idea there is that, these folks get together for meetings on a quarterly basis, maybe, and that's about all they ever do. What is sort of the downside risk, or why would they want to maybe go ahead and pay the $900 and get that coverage for workers' comp for people who it seems like all they do is sit in the chair and make decisions?
Well, I agree with you. Don't get me wrong. I think it's just the way the statute was written. It's a slip and fall, and somebody's health insurance declines it because they find out it was something that occurred in the act related to a municipal function. their health insurance has every right to deny that claim. It's especially in this day and age when other insurance policies such as health insurance are so restrictive in nature and trying to save every dollar they can, they're going to look for ways to subrogate every dollar they can. And so it's in your best interest to purchase a workers' comp policy. That's what we always say, because we're trying to avoid the risk should something happen.
Yeah.
And the risk is very low, but unfortunately, Wisconsin State Statute, Chapter 102.04, yeah, it's pretty clear about lake districts and workers' compensation. So,
and I usually explain it to say that when workers' comp was first being introduced in Wisconsin, it was sort of a state government initiative. It was the idea that we could create this pool for everybody to make it a lot, how to put it, easier for employees and easier for employers. But it certainly was seen as a new thing and a change of how things are being done. And so if the state of Wisconsin said, yeah, this is just for corporations or other people, this isn't for us, of course, the state of Wisconsin and the local governments aren't going to have to participate in this,
right.
Then that would have gone over like a lead balloon. But instead they came out and said, you know what, we're going to participate in this as well. The state of Wisconsin, every employee for the state and every public employee for everything down to a lake district is also going to participate in this, so that we're not trying to make other people do something that government itself isn't willing to do.
Yeah, and think about it in this day and age when health insurance deductibles are on the rise and there's caps on coverage. Workers' compensation hasn't changed in that regard, where it's first dollar coverage for somebody injured in the course of work related to work, or let's say I don't know how many municipalities I have that inspections are very, very common. They go out as a district, they go out as a board, and they check things out. Well, if somebody gets injured, you're not worrying about, I have a $2,500 deductible and this and this and that. Workers' comp picks it up first dollar. And there is no limit on medical cost coverage on a work comp policy. So it is a good thing to have, even though the likelihood of something occurring is very, very small. It's out there. It's easy to get. Yes, it's $900, but again, don't risk a lot for a little. And there's a reason the state, like you said, Eric, there's a reason the state said you should have it.
So I hate to, just to butt in, this is Larry again. So I was back here looking in the People of the Lakes guides. And somehow our organization has missed this. So it is a state requirement that we have workers' comp, correct?
Yes.
Okay, okay. All right, thank you.
Peter, it looks like
What Nathan and I were just saying is, if you didn't have it, you may go many years without it becoming an issue, but then suddenly there's going to be a year where it does become an issue and you're going to wish you had it. And I don't think you can just say, oh, we didn't know. I think, again, a different insurance company is going to come after the district and find out whether or not it has that policy.
If a member slips and falls and hurts themselves, okay, in a district, and they do not have workers' compensation, and their personal insurance declines that claim, the Lake District could be held liable for those injuries and any costs associated with that. That's the unfortunate reality of it.
And we're talking about board members here. We say
Just anybody. I mean, yeah. A lot of times it really only comes into play if you have most lake districts that have functions or have employees, they have workers' compensation because it makes more sense. But even if you have just a board, you still need it.
Yeah.
So at an annual meeting, if someone was injured going to the annual meeting, or in the auditorium where we have the annual meeting, is that a liability to the district or a workman's comp thing to the district?
If it's a board member that's injured, then it's workers' comp. If it's a citizen, for example, coming into that auditorium, it could be a general liability.
I noticed that Peter is unmuted, and Peter, I wondered if you were wanting to follow up in your question about unincorporated associations.
Yeah, and I put something in the chat, and I guess perhaps it's just that our lake is so small, but it seems very typical in the area. We're from Vilas County. It sounds like good legal advice, if you will, if as an alternative to getting insurance is to avoid ownership of assets, to avoid doing anything other than information campaigns. Certainly don't act like you can exert control. So you know, a very common activity is to support loan platforms, maybe share in the cost of some outside the township paving campaigns, a sticker program to make sure that we know when there's somebody on the lake who might have come on through an unauthorized landing, things like that. So it sounds like we should limit our activities to things like that and to thus avoid risk. And maybe that's more of a question for Jessica, I guess. And the reason I ask is because while we're sound trivial, it's a very common structure for small lakes, at least in Vilas County. You know, they have environmental concerns, and that's it.
Right.
Right. And I hear where you're coming from, for sure. And at the same time, it kind of feels like, I mean, are you having the tail wag the dog kind of thing? I mean, I think I would focus more on what activities do we want to accomplish as a lake association, and then figure out there's some costs of doing business. And perhaps if really to do the activities that you really want, that there's, you know, you need some insurance for to minimize, you know, protect your directors and the organization itself. So I mean, that is the flip strategy, is minimize your activities as much as you can. However, you can always get sued. You just don't have a lot of control over that. So there's definitely, you can't control other people, I guess. You can only control your own activities. And so I think you know, maybe the cost of business is just get some insurance and then have a little more breathing space to do more activities.
Right. I think we're going to have to leave it at that. It is 5:30, so it's time for us to conclude. Thank you to everyone. I knew we'd have lots of robust questions and probably could keep going on this well into the evening. So maybe we'll do this again sometime. Certainly reach out to any of us with questions, and if we don't know the answers, we can get them to you. And a big thanks to both Jessica and Nathan for providing such great commentary and knowledge. So virtual hand claps to both of you. Thank you so much.
Thanks for inviting me.
Thank you, everybody. Have a great evening.
Again, next week, May 13th, it's the Lake District Treasure 1. And then we've got other programs slated every Thursday at 4 up until June 10th. So, and if there's interest in enough topics, we might keep on going deeper into the summer. We know that as we get deeper into the summer, maybe people won't want to be joining us at 4 o'clock on a Thursday, but we've enjoyed everything we've done so far. You can you register for next week at the same webpage that you signed up for this one, and you can also view, you'll be able to view the video from today's event and the past week's events there as well. With that, I'll conclude. Thank you, everybody.